Hi everyone, welcome back to another episode on the history of the Ottoman Empire. I'm Nir Shafir, and I will be speaking today about the nature of law in the Ottoman Empire and how it transformed during Ottoman rule. Now, this is a complicated topic, and I just want to say from the very first, when we speak about law, that is, we're actually speaking about three different types of law at work. Now we're going to be focusing on one of those in particular, that is the Sharia, this one in the middle, what we often consider as Islamic law. But there was other forms of law around, such as Qanun. Qanun we might consider as law decreed by the Sultan or ruler. Could be, I guess, decided as secular law. It usually is, in this case, things that dealt with how to structure the government, how to pay raises, hierarchies, but also questions about, for example, ensuring safe passage of merchants or people through lands, etc. This was the realm of Qanun. In some ways, it was very limited, and it's very different from our vision today of law, where we have basically secular law controls all things that are deemed under law. That is from, workplace-related events to disputes to questions about murder, etc. That's all done by a legislative body, which is created by the state. But in this case, the Sultan and ruler actually creates a much smaller amount of law, and that's called the Qanun. Okay. Now, the majority of law, though, that existed was what is called Sharia, and we'll get into that in a second. This is law created not by the state, not by people invested with the power by the state necessarily, but by, technically, up until the Ottoman period, by independent jurists, scholars who were creating law as part of their work. And then on top of that, there's something we might call urf. Urf is law, customary law. It's basically just the way things are done in a local place or time. In our village, we always divided the land like this, or we made, everyone switched fields every few years, etc. This was just kind of local custom, but sometimes this held a specific legal weight. It was never formalized, it wasn't written down, but it was there. And we have a kind of similar thing today in our society. For example, the regulations of UCSD, they don't have any legal bearing. They cannot go against the laws of the state of California and their federal laws. But UCSD has its own regulations about, drop and add dates, about what is cheating, about what is acceptable behavior, etc. These might be considered customary law of our local space. One last thing I want to point out, Sharia. Today we think about law as something that deals with transactions between humans. When someone murders someone else, someone cheats someone else, or you want to, for example, set up a fund, an endowment, or a trust fund or something like that. But Sharia actually covers a whole variety of other stuff, especially if it covers relationships not only between humans, but also between humans and God. Now, this is kind of important because it actually means that Sharia can actually cover things like how should you pray, what should you believe in. Lots of these sorts of questions are also encountered in Sharia and are not encountered in our modern legal system. But before we jump into that, let's look into what is Sharia. Now, if you go online, there's going to be a ton of Islamophobic, crazy stuff out there claiming, for example, that Sharia is a menace to Western civilization, that it's out there to infiltrate American society or other Western societies, and basically none of that is true. This is all ridiculous. Not only that, because the more basic point of law is that law can only be enforced by a state. And as long as that state, in this case the United States or wherever, is not attempting to formally, is not applying Sharia in the basis of the findings of Islamic law, that's never going to happen. So this is not an issue in any way whatsoever, but it does go to show you just how much, let's say, bad faith information there is out there about the nature of Islamic law and what it can and cannot do. And in fact, people often see it as some sort of backwards, unmodern, form a legal system that can't actually adapt and transform, but we'll see that's actually not true. Now, so what actually is Sharia? Sharia literally just means the way or the path, and it's often translated as Islamic law. But then we have this question, well, what really makes it Islamic? Well, the answer to that is that it also is based on the basic sources that it's using to establish like precedents, etc., is this question of the sources are the Quran and the sayings and deeds of the Prophet Muhammad. And from these are built up very complex legal theories. And as I pointed out, this is not the only system of law in the Middle East. Not only is there qanun and kind of customary law, but there's actually also basically other religious forms of law out there. So the Christians and the Jews had their own religious courts, which they used to resolve disputes among themselves according to rabbinic law or to other forms of law. But these were always, in a sense, subsumed under the Ottoman system of law. They only applied to those communities themselves. Now, what we're going to look at is basically how did it function as a system of law? We'll talk a bit about how it's different from our current system of law, which we've already talked about, and ultimately, how did the Ottoman state transform law in this period? Now, to make any sense of this, we have to jump into the basics of Islamic law. Now, one thing to think about is this fact: is Islamic law codified? Are there laws written down in a single law book? And unlike, for example, our society, where we have the state of California, the legislative branch creates laws, and these are written down, and new laws are then published and then become part of the law books, in which then the judges interpret them and bring out judgments. This is not the case with Islamic law. There is no formal space in which all law is written down. Instead, what you have is a set of cases and opinions built up over centuries that kind of establish both methodology and ideas, and ultimately also just kind of common sense cases. So it's every time, basically there's nothing written down, but it doesn't mean that they start from ground zero every time, or a judge just makes up an opinion. If someone murders someone and the case is pretty cut and dry, it's very clear what's going to happen, and there's very set, clear punishments and procedures to do that, to investigate it. But let's jump into the more basic things here, which is what are the two Islamic roles in Islamic law? So we have two roles here. One is the qadi. I wrote as a judge. He could also be a magistrate in the Ottoman period. He was a state official, often charged with basically also helping to run an area. But in his role in Islamic law, he basically makes judgments on specific cases. So a petitioner will bring him a grievance. The grievance will then be investigated. The judge will then call witnesses, etc. Call the two parties. They'll call witnesses. Then the judge will make a ruling on that case. So that is the work of the judge, basically. Now, the work of making the law, of issuing legal opinions, is the work of a mufti. And a legal opinion is called a fatwa. So someone who makes fatwas is a mufti, and has the same root, fatwa, in it. And he's the one who's supposed to read the legal sources, think it through, think about the ideas in there, and issue basically a yes and no answer to a new legal question. Now, the interesting thing is that because the jurists are not appointed initially by the state, for the first 1,000 years of Islamic law, the jurists were independent. Right? The judges were appointed by the state, but the jurists were independent. And because they weren't appointed by the state, there was no hierarchy there. Anyone could put out a legal opinion, and still today anyone can put out a legal opinion. And what is the weight it is attached to it is based off of your reputation, your knowledge, your piety, etc. And these would lead certain legal opinions to rise above others. Now, in our legal system, we have things a bit different, right? So in our legal system, the judge kind of combines both of those, in that the judge both rules on specific cases, but also can create precedent by his rulings. Of course, the legislative branch also creates laws. But in this case, it's different, right? So the mufti is thinking about the legal theory, the qadi is actually putting it into practice, okay? And so also the qadi is appointed by the ruler, the mufti is independent, okay? So keep this in mind because it's going to be an important change when we think about what changed with the Ottomans. Now, what's interesting is that especially during the Ottoman period from 1550 onwards, you start getting very elaborate court records preserved. Now, there probably were court records before, but they're the private property of the judge. But now, after 1550, court records become a sort of public register, and you get all sorts of weird stuff showing up. Like this event, a caravanserai raided, a woman is apprehended drunk. So if we look at it, we're saying, the Janissary Bekir bin Abdullah, so a soldier from the patrolman of the Mamure neighborhood, appeared in the court of law and stated, I was informed that some toughs bring prostitutes to the caravanserai of Arpaja Hussein. So, okay, they suspect a sort of prostitution operation. I went there together with undersigned Muslims, but the fellows fled. One left his raincoat, his jacket, his vest, his belt, 2 old felt caps, an old shirt, and his muslin. 2 Shahi coins were also found in his clothes. After much tumult and searching, we found this Fatma binti Mehmed among them and brought her here. She's still drunk, her mouth smells of wine. Okay, so they basically are trying to bust this prostitution ring. The pimps flee, or the men flee, and all that's left is this woman who they get, and she's basically drunk. When the aforementioned woman was asked, she was unable to deny. Unclear what, deny being drunk. On request, it was recorded that she was drunk and her mouth smelled of wine. It's been recorded that the woman was given over to the chief of police, Ahmed. So, then you have when it was written, and then you have the witnesses. Here's basically a sort of like police record, like it's not even the judge issuing an event here. It's just an interesting, basically a police bringing this event to the judge and having it noted down. It's unclear what ended up happening to her or what punishment may or may not have been given to her. But you get a sense of the things that are in these court records. Other times you get official orders like this one here, in which the city of Istanbul was supposed to be illuminated upon the conquest of a province, I believe in what's today southern Poland, modern-day Slovakia, sorry. You get all sorts of different material in these court records, but often you get also essentially court cases. Sometimes they're very silly, like in this case. The reason for drafting this record is Ali bin Abdullah and Mehmed bin Ilyas. So Ali, son of Abdullah, and Mehmed, son of Ilyas, of the village of Qadi, appeared at the court of law. Okay. One of the interesting things here, by the way, is that there is no prosecutor. So the state doesn't go out and try to find criminals. The court only hears cases that are brought before it by plaintiffs. So it has to have an aggrieved person coming and opening a case against someone else. So Ali brought the claim. He said, one of my horses walked loose at night and entered your vineyard, and you cut off its tail as a punishment. Mehmed was questioned. He denied the allegation. When proof was demanded of Ali, he was incapable of producing any. Mehmed was asked to swear by God 3 times, from which he abstained. It was recorded as a register in the register on request. So it's unclear what's going on here. 2 neighbors are fighting. A horse was mutilated. But they don't really have any evidence, right? They don't have any witnesses, of course. They don't have anything going on. I mean, there's witnesses to this proceeding, but they don't have any witnesses of what happened there. But it was they asked to have it registered in the register, right? They wanted it written down, so maybe if a future event occurs, they can go back to it. One of the interesting things here is also the fact that, when they don't have proof, they go back into this question of swearing, taking an oath. And this was very common practice. that when you had a situation in which someone could not produce clear proof, they were asked to swear. In this case, it's interesting that Muhammad refused, which probably says a lot about his sense of guilt, and also the idea that people were really unwilling to swear by God in vain. Now, we've seen some of these court records. I didn't give you the kind of more normal ones, but I give you some of the funnier ones. But here are examples of fatwas, right? Legal opinions. Now, remember, these legal opinions, they're just one person's legal opinion. They don't have direct standing. But here we can see, for example, in one site, let's just look at some other things they talk about. It says, in one site, in a village, the Christians claimed that Jesus, utmost peace and prayers upon him and the prophets, was born. They built upon the site a church and erected in it statues and paintings, but Jesus' birth in the site is not confirmed by an authoritative or correct source. Is it acceptable for a Muslim to enter the church for the purposes of pilgrimage or not? So this was actually a legal question submitted to Chataljit Ali Effendi, one of the important Shaykh al-Islams in the early 1700s. And in it, what you can see is that actually all the personal information has been taken out. We don't know who brought up the case. We don't know where this village is. We don't know anything. It's been abstracted so that the basic legal question is there. Okay, like, can you perform pilgrimage to, is it acceptable for a Muslim to enter this church for purposes of pilgrimage when it's not clear or not that this place is really the tomb of Jesus? And of course, Jesus is considered a prophet in Islam, so it would be beneficial to go on pilgrimage to that place. And this goes again, shows how law was much more expansive than what we would imagine today, or at least in our conceptions of law. Another funny one is this: is it permissible to take a glass bowl or a glass cup of wine, place it in a bright location, and look at it with pleasure? Now, of course, the problem here is there's a few different ones, but the question here is, you're not supposed to drink wine. You're not supposed to drink any intoxicant. But is it okay to look at it, to enjoy it? And if so, does that visual impact of it have a transformation on you? And the response maybe reasonably says it's permissible but not encouraged. Now, these can go also more seriously, like in the fatwas that we looked at by Abu Saud against the Kizilbash. Right, a question was asked, is it legally and religiously permissible to fight against the Kizilbash? When the supporters of Shah Ismail, are those who kill the Kizilbash deemed holy warriors? Are they killed by them as martyrs? And he says, yes, war against them is permissible. It's a holy war deserving the highest reward. Theirs is the greatest martyrdom. So what he's using, because of this guy's at the top of the legal hierarchies, we'll see he's using these fatwas to transform the fight against the Kizilbash from a political rebellion into a religious one. It becomes a holy war. It's seen as something much more serious than just a small rebellion. And we see this again in the next fatwa. We're going to skip that for the interest of time. But here's a question though: what do you do when something is not mentioned in Islamic law or in its sources? What if a new substance or a new legal problem comes about? Well, obviously you would ask for a fatwa, but how do they then decide these issues? So, for example, let's take a real-life question that appeared around the 1550s in the Ottoman Empire, which is the question of, is it permissible to drink coffee? Now, coffee is a relatively new plant introduced from probably the highlands of Yemen or Ethiopia into the Middle East, and from there to the rest of the world. And we know that it was initially used in Sufi rituals in the 15th century because it was helpful to keep people awake. They probably just ground the beans and boiled them. Maybe they roasted them. Obviously, it wasn't drank with any sugar or with any milk. And it was initially a sort of religious accoutrement to help people conduct the dhikr ceremonies, etc. But then it slowly and actually quickly moved out of that religious sphere and into just everyday life. And then we start seeing coffee being drank in Mecca and Medina and Cairo, and then by 1550 in Istanbul itself. And then it quickly takes off. On the left, we have a picture of the first coffee house, or the only picture of a coffee house from Ottoman miniatures visual sources. On the right is a model of a coffee house on parade at a guild parade. But there's also bigger questions about is it permissible to drink coffee? How would you decide this? Especially because obviously coffee wasn't around when the Quran was revealed. At times of the Prophet Muhammad, it wasn't around, so there has nothing to say it. So how do you actually navigate that space? Well, you basically balance all the different sources from different major legal scholars to different hadiths, different ideas about what is permissible or not. In this case, the question ultimately revolved around the question of whether coffee is intoxicating, because the idea is that all intoxication is bad. Anything that intoxicates you, that makes you lose your mind in a sense, can hurt your very being and is therefore banned. And that was the traditional ban on alcohol. But now the question is, well, does that actually also apply to coffee? Now you may think today this is nothing, but we also have to think back in the time. This is one of the first psychotropic substances that were out there, and it probably would have had a much stronger impact initially, and people would have, there would also be a good amount of fear and excitement about it, and this would create other kind of more hysteric reactions to it. Ultimately, what's interesting is that they would judge that the coffee would be actually prohibited, but over time, as it became more and more consumed and became part of everyday life, it was eventually moved into the kind of neutral or discouraged space. And so we can actually see how things like coffee, or also tobacco, which is a much stronger debate, became gradually naturalized, and the opinion of Islamic law changed over time to accommodate them, because that was, again, daily habit, local custom that became reflected in the nature of the opinions. Now, I won't go too deep into this, but the basic idea here, again, as we pointed out, is that there's two basic sources of Islamic law: the Quran, and then which is the Word of God revealed to the Prophet Muhammad. It's written down in the book. Today, we have access to it, but it's very difficult to interpret, and it doesn't actually tell us that much about what to do or how to behave. Instead, you need to look at the Sunnah, the tradition, which are actions and words of the Prophet Muhammad. These are called hadith, and these help you interpret the Quran, but they also help you understand what is, they become kind of an authoritative precedent. Scholars would use them and extrapolate from them through analogy to understand open new questions. So as I pointed out, in the case of coffee, they would say, well, coffee is like an intoxicant. All intoxicants are banned. Therefore, coffee is banned. They would use exactly that kind of type of basic syllogistic ideas to reason through this. One of the interesting things that I won't get into here, but the point is that this is a world in which scholars chose what the law was. The ruler doesn't actually have any say in creating the law. And so it was ultimately up to the scholars. The most the ruler could do, at least until the Ottomans, was essentially appoint the judges, but they couldn't appoint the scholars themselves. Now, I won't go into this too deeply, but once you start from, when you have a new question or something, you basically take your sources, you take the legal scholarship, and then you can use different techniques, analogy, consensus, reasoning, precedents, etc., to basically explain your decision and why you think it comes up, why it would work like that. And so this basically, they developed different schools of law depending on what different founders of schools of law believed was the role of individual reasoning or specific aspects of these legal maneuvers. Initially, there was actually over 50 schools of law, but basically it narrowed down eventually to 4 main ones that we'll see in a second. And each of them kind of gave slightly different answers to the same legal questions. Sometimes this could be actually consequential, more than just a question of scholastic differences. So, for example, the Hanafi school actually provided women much more basically alimony or rights in divorce cases than other schools of law. And therefore, when you have a judge, for example, in the Mamluk, in certain places in the Mamluk lands, they would have a judge from each of the schools of law. And so people would often opt to go to the Hanafi one rather than the Shafi'i or the Maliki, as we'll see in a second, to go to have that type of legal opinion. It's called forum shopping. So there's 4 basic legal schools. One of them is by a figure named Shafi'i, founded by al-Shafi'i. He wrote probably kind of the founder of Islamic law. Another figure is Hanafi, by a guy named Abu Hanifa. He has more space for individual reasoning. Maliki is another person centered around Medina at that time. And then Hanbali, a very small legal school, but having little space for individual reasoning. For our purposes, the only important one is the Hanafis. That was the Ottoman one. But they also encountered a lot of Shafi'is in the Arab world because that was the predominant legal school at that time. Malikis are mostly in North Africa, and Hanbalis are different small communities throughout. So we're going to stop there for a second. We'll talk more about the Ottoman impact on Ottoman law in the next section.